6. Arguing effectively 2. Speculative arguments. Hey Alex. As promised, here's another letter on arguing effectively. Just to finish up the point I left the last letter on. I don't think the argument from analogy presented at the end of that letter works to establish that Mandy has a right to an abortion. There is one big difference between Samantha's case and Mandy's case. In Samantha's case, the doctors violated her rights in hooking her up to Frederick. So requiring her to remain hooked up to Frederick would perpetuate the injustice that she initially suffered when the doctors started meddling with her body. In Mandy's case, no one violated her rights in getting her pregnant. So there would be no injustice in requiring her to remain pregnant for the 9 months necessary to give birth to the fetus inside her. It would be different if Mandy had been raped when she was drunk, and that is why she is now pregnant in that case. Her situation would be very similar to Samantha's, and if Samantha does indeed have a right to disconnect herself from Frederick, then that would seem to establish by analogy that Mandy should have a right to have an abortion in the case where she was raped, and that is why she is now pregnant. I want to talk now about the other very common form of argument that you will make and come across as a lawyer and in life generally. That is a speculative argument. This kind of argument takes the following kind of form. 1. Every swan I have ever seen has been white. Given this, it is sensible to suppose that 2. All swans are white. Again, step 1 in the argument is called the premise of the argument. Step 2 is the conclusion. There are 2 important differences between logical arguments and speculative arguments. First, a logical argument starts from a generality and then moves from that generality to reach a conclusion about a specific thing. In contrast, a speculative argument goes in the opposite direction. It moves from a statement about a specific thing to reach a general conclusion about that kind of thing. Secondly, you'll note that unlike with a logical argument, a speculative argument can have only one premise for its conclusion. You'll recall that any logical argument must have at least 2 premises to support its conclusion. If it has only one, it doesn't work. This is because the conclusion in a speculative argument does not follow logically from its premise or premises. It does not necessarily follow that all swans are white just because every swan I have ever seen has been white. It may be that not all swans are white, and I just happen never to have seen a non-white swan. In fact, not all swans are white. Black swans exist in Australia. So as it happens, we should reject the conclusion, all swans are white. But as a general rule, if the premises of a speculative argument are correct, and the conclusion of that argument seems the most sensible one to draw from those premises, we should accept that conclusion until we are given good reason to think that it is not true. So up until the time Australia was discovered by Europeans, it was rational for Europeans to think that all swans were white, because no European had seen anything but a white swan. But as soon as black swans were observed in Australia, Europeans no longer had good reason to think that all swans were white. Just in case you are tempted by the non-logical nature of speculative arguments to think that there is something dodgy about them, I should point out that scientists make speculative arguments all the time, and that all scientific progress depends on such arguments being made. 1. Every time we throw an object into the air, it falls back down towards the earth. Given this, it is sensible to suppose that 2. There exists a force, call it gravity, which pulls an object thrown into the air back down towards the earth. Lawyers often reason like scientists. They will take a case or a line of cases and try to extrapolate from the results of those cases a rule or a principle which explains the results in that case, or those cases. Having done this, they then argue that that case or those cases establish that that particular rule or principle is part of English law. When a lawyer makes an argument like this, the argument will always be speculative in nature. So, for example, in the 1995 case of Spring v. Guardian Assurance plc, the defendant gave the claimant, an ex-employee of his, a bad reference. The House of Lords held that if the claimant did not deserve a bad reference and the defendant had been careless in preparing the reference, then the claimant could sue the defendant. The defendant, the House of Lords held, had owed the claimant a duty of care in preparing the reference, and if he breached that duty, then the claimant could sue him. Now, what legal rule or principle was the House of Lords relying on, and therefore introducing into English law in deciding this case? One lawyer might argue that the House of Lords thought that whenever one person gives another a reference, the referee will owe the subject of the reference a duty to prepare the reference with a reasonable degree of care and skill. Another lawyer might argue that the rule the House of Lords was actually relying on in deciding Spring was, whenever an employer gives an ex-employee a reference, the employer will owe his ex-employee a duty to prepare the reference with a reasonable degree of care and skill. It makes a big difference who is right. If the first lawyer is right, then if I undeservedly and carelessly give an ex-student a bad reference, then Spring v. Guardian Assurance plc establishes that my ex-student can sue me. I owed him or her a duty of care in preparing the reference. If the second lawyer is right, then Spring v. Guardian Assurance plc does not establish any such thing. My ex-student was not a former employee of mine, so Spring v. Guardian Assurance plc has nothing to do with my case. Whichever argument as to what the Spring case establishes is correct, both arguments are speculative in nature. They both take the basic form. 1. In Spring v. Guardian Assurance plc, the House of Lords decided that, given this, it is sensible to suppose that 2. The House of Lords thought that an employer referee will owe an ex-employee subject of the reference a duty of care in writing a reference for him or her. This is not a logical argument because 2 does not follow logically from 1. Whatever you think was basis of the decision of the House of Lords in the Spring case, there will always be other possible explanations of the House of Lords' decision in that case. So we can only determine what was the basis of the House of Lords' decision in the Spring case by asking ourselves, what is the most sensible explanation of the House of Lords' decision in Spring? Lawyers don't just make speculative arguments when they are trying to clarify what rule or principle underlay a particular case or line of cases. They also make speculative arguments when they are called upon to clarify what a particular legal word or concept means so that they can apply a particular legal rule which contains that word. So, for example, the law says that you will violate my rights in legal parlance, commit a tort if you directly interfere with goods that are in my possession when you have no legal justification or excuse for doing so. But when can we say that goods are in my possession? What if I own a flat in Glasgow? Are the things inside that flat in my possession while I am typing this letter in Cambridge? What if I drop my wallet in the street? Is the wallet still in my possession while it is lying in the street? If a friend of mine sees the wallet fall out of my coat and picks it up, intending to give it back, is it in my possession at that point? To answer these questions, we look at all the cases which have something to say about when goods were and were not in someone else's possession, and construct from them a definition of when we can say that goods are in someone's possession. But coming up with a definition will involve making a speculative argument. It will involve making an argument along the following lines. 1. Case A said that goods were in X's possession, when Case B said that Y lost possession of goods, when Case C said that Z obtained possession of goods, when, given this, it is sensible to suppose that 2. Goods will be in someone's possession, if and only if, having clarified why lawyers make speculative arguments at all, I'll now give you a bit of guidance as to what you should and shouldn't do in making speculative arguments of your own. As usual, my hope is that this guidance will help you make good, effective speculative arguments, as well as helping you spot any flaws in speculative arguments that you come across in your reading. A speculative argument based on a false premise is worthless. One thing that speculative arguments have in common with logical arguments is that a false premise will undermine a speculative argument just as effectively as it will a logical argument. If I argue that 1. In Spring v. Guardian Assurance plc, the House of Lords ruled that the defendant did not owe the claimant a duty of care in writing a reference for him. Given this, it is sensible to suppose that 2. Whatever conclusion I draw from premise 1 will certainly not be worth the paper it's written on. Most cannot mean all. Suppose that Charles is a well-traveled man who has been to Australia. He gets into an argument one day down the pub about whether all swans are white. He argues, 1. Most of the swans I have seen in my life have been white. Given this, it is sensible to suppose that 2. All swans are white. There is something wrong with this argument. If 1 is true, then 2 cannot be true. If most of the swans Charles has seen in his life have been white, then it follows that some of the swans Charles has seen have not been white. And if some of the swans Charles has seen have not been white, then it cannot be true that all swans are white. So, in making a speculative argument, you cannot infer that X is true of all NS based on the premise that X is only true of most NS. In fact, the only thing you can infer from this premise is that X is not true of all NS. This elementary point is quite often overlooked by academics writing about the law. For example, as a law student, you will come across statements such as, the first requisite of a contract is that the parties have reached agreement, or the function of tort law is to determine when one person may justly be required to compensate another for a loss that that other has suffered, or, under English law, Parliament is sovereign, which means that a law created by Parliament must be given effect to by the courts until it is repealed by Parliament. But if you read on and look hard at what you are reading, you'll see that the only evidence given in support of these statements is that most contracts are based on agreement, and it is acknowledged at the same time that some contracts can be made without the parties having reached any kind of agreement at all. Most tort cases involve one person suing another for compensation, and it is acknowledged at the same time that there are some tort cases where the person suing isn't looking for compensation at all, but for some other remedy such as an injunction. Most laws created by Parliament are binding on the courts, and it is acknowledged at the same time that laws purporting to bind what future parliaments may do are of no effect. So in fact, what the textbooks should be telling you is that you can make a contract with someone else without having reached an agreement with them. Whatever the function of tort law might be, it is not just to determine when one person may justly be required to pay compensation to someone else. Under English law, Parliament is not completely sovereign. There are limits on what sort of laws created by Parliament will be binding on the courts. Notice that the last 3 statements are more interesting than the first 3 because they contradict the bog standard accounts of English law that are routinely trotted out in the textbooks. Interesting statements about the law are much more likely to get high marks from your examiners than statements that have been lifted straight out of a textbook. So long, that is, as you have backed up your interesting statement with a good argument. So remembering that what is acknowledged to be only true of most cannot possibly be true of all will not only help ensure that you get a much accurate understanding of the current state of English law than some of your textbooks may give you, it may also help you do well in your exams. Don't oversimplify. A bad habit that you should avoid in advancing a speculative argument is that of oversimplification. Your explanations should take account of the complexities of what you are trying to explain. So, for example, suppose there is a line of cases F. In cases D, it could be argued that the courts relied on Rule R to reach their decision. So cases D seem to indicate that Rule R is part of English law. But if Rule R were part of English law, we would have expected cases E and F not to have been decided the way they were. Let's suppose that academic analyzes these cases in the course of an article. Let's suppose further that academic suffers as academics sometimes do from the bad habit of oversimplification. Academic will probably argue that 1. Case A says, Case B says, Case C says, Case D says. Given this, it is sensible to suppose that 2. Rule R is part of English law. Cases E and F are simply ignored. If one forcibly brings cases E and F to academics' attention, he will almost always simply dismiss cases E and F as wrongly decided. But they're only wrongly decided if Rule R is part of English law, which is what we are trying to establish in the first place. It would be more honest and straightforward to argue as follows. 1. Case A says, Case B says, Case C says, Case D says. Given this, it is sensible to suppose that 2. In these cases, the courts took the view that Rule R is part of English law. But 3. Case E says, and Case F says. Given this, it is sensible to suppose that 4. In these cases, the courts did not take the view that Rule R is part of English law. Given 2 and 4, it is sensible to suppose that 5. It is uncertain whether Rule R is part of English law or not. A majority of cases seem to take the view that it is, but a minority seem to take the view that it is not. This conclusion fits more of the cases than academics does, and therefore gives us a better account of the current state of English law than academic gives us. Moreover, this conclusion is more nuanced, and therefore more interesting than academics' conclusion. So someone who argues in favor of this conclusion in an exam is likely to do better than someone who adopts academics' line. Academics are particularly prone to falling into the vice of oversimplification whenever they try to define a particular legal term or concept. This is because academics tend to assume that there is a one-to-one relation between legal terms and definitions. As a result, they tend to think that a particular legal term is always used in the same way to mean the same thing. So, for example, academics have endless debates over what it means to have a legal right. Some argue that when we say Len has a legal right, we are saying that Len has an interest, which is protected by the laws imposing duties on other people not to violate that interest. Others argue that we are saying that Len has a power to do something that is either given to him by the law or is protected by the law. The possibility that when we say that Len has a legal right, we could mean either of those things, depending on the context, doesn't get a look in. A similar point can be made about the term trust. Academics tend to assume that when we talk about a trust, as in a holds this property on trust, we are always talking about the same thing. And so they ask, what are the characteristics of a trust? How is a trust created? And who has an interest in property that is the subject of a trust? They hardly ever consider the possibility that in fact the term trust does not refer to one thing, but in fact refers to a variety of different legal arrangements which bear a family resemblance to each other, but have nothing more in common than that. If this is the case, it simply makes no sense to ask, what are the characteristics of a trust? How is a trust created? And who has an interest in property that is the subject of a trust? The proper response to these questions can only be another question. What sort of trust are you talking about? You should aim higher. Always be on the lookout for definitional oversimplification, and avoid it like the plague wherever you come across it. Definitional oversimplification always involves a false economy. It just stores up trouble in the long run. Don't overcomplicate. Just as you shouldn't oversimplify in making a speculative argument, you also shouldn't overcomplicate. The most sensible explanation is usually the most simple. This principle of argumentation is known as Occam's razor. So, for example, consider the following argument. 1. Case A says. Case B says. Case Y says. Case Z says. Given this, it is sensible to suppose that 2. All judges belong to a secret society, the leaders of which dictate to them how they should decide their cases. No, this is not sensible at all. The reason why this is not sensible is that for 2 to be true, all of these things would also have to be true. 1. There exists a society which has some means of contacting any judge who is appointed to the bench. 2. Membership of this society is so attractive that every judge who is approached agrees to become a member of it. 3. The leaders of this society are so charismatic that every judge who becomes a member of this society is happy to do whatever they say. And 4. This society has some way of ensuring no word of its existence ever escapes into the media. So in fact 2 provides us with an incredibly complex explanation of how the cases in 1 were decided. and incredibly complex explanations are very unlikely to be correct. For the same reason, it is highly unlikely that judges decide cases the way they do in order to maximize the wealth of society. Many academics, particularly in the United States, believe this. Academics who take this view belong to what is called the law and economics school of legal thought. For this to be true, it would also have to be true that all judges, in making their decisions, are interested in promoting wealth maximization to the exclusion of all other considerations, such as promoting equality of opportunity, or helping the needy, or maximizing everyone's liberty. Roman 2 All judges are equipped with the economic knowledge that would enable them to determine what rules they should give effect to so as to maximize the wealth of society. Roman 3 All judges have agreed that they should keep the fact that their only concern in deciding cases is to maximize the wealth of society completely secret, and not allow a word of this to enter into their judgments. Roman 4 Barristers who argue cases before judges must be taken to be unaware of this agenda of the judges, because they too fail to mention wealth maximization in their arguments. But as soon as a barrister becomes a judge, he or she suddenly becomes interested in promoting wealth maximization to the exclusion of all other considerations, while at the same time acknowledging the need to keep quiet about this desire. All this is just so complicated that it makes wealth maximization completely implausible as an explanation of why judges decide cases the way they do. Don't be dogmatic. The final point I want to make about making speculative arguments is that you should always remember that they are speculative. As the facts on the ground that you are trying to explain change, you must be ready to change your explanations with them. For example, the decisions in cases A, B, C, and D may have led you to conclude that Rule R is part of English law. If case E comes along and seems to deny that Rule R is part of English law, you can't let yourself be carried away by a sentimental attachment to Rule R into denouncing case E as wrongly decided. You have to be ready to concede that the decision in case E has made the law uncertain and made it difficult to tell whether Rule R is part of English law or not. A great example of this willingness to change is provided by the late academic Professor Peter Birks. A lot of his work focused on the legal rule that if A has been unjustly enriched at B's expense, then B will be entitled to bring a claim for restitution against A and recover the value of that enrichment from A, so long of course as A cannot raise a defense to B's claim. But what does it mean to say that A has been unjustly enriched at B's expense? For about 20 years, Peter Birks argued on the basis of a close analysis of the relevant cases that A will be unjustly enriched at B's expense if A obtains wealth from B without B's consent or under circumstances which meant B's consent to A's having that wealth was flawed in some way, because it was given because of a mistake or under duress, or in expectation of something being given in return that never came. But in 1994 a case was decided, Westdeutsche Landesbank v. Islington, LBC, that did not fit Peter Birks' theory of unjust enrichment. In that case, B was allowed to recover money that it had obtained from B, even though B had consented to A's having that money, and there were no facts in the case that allowed us to say that B's consent to A's having that money was flawed in some way. Instead, B's claim to recover the money he had paid A was allowed simply because, unknown to both A and B at the time, the contract under which B had paid A the money happened to be invalid. So how did Peter Birks react? Well, he didn't reach for his gun and attempt to shoot down the decision in Westdeutsche Landesbank by denouncing it as wrongly decided. Instead, he did something amazing. He junked the definition of when A will be unjustly enriched at B's expense that he had been advancing for the previous 20 years, and for the last few years of his life, he argued that A will be unjustly enriched at B's expense if it obtains wealth from B, and there is no valid legal basis for the transfer of wealth. This new definition was, he argued, superior to the old, because it accounted both for the old cases on which his old definition was based, and it also accounted for the decision in the Westdeutsche Landesbank case. Summary. I'll now briefly attempt a summary of what I've said in the last 2 letters. When making a logical argument, make sure that it isn't circular, that is, that it doesn't assume what it's trying to prove. Check that the conclusion follows logically from the premises, and that you haven't done something silly like try to derive an ought from an is, and ensure that your argument isn't based on a false premise. The last point also applies when making a speculative argument. But when you make a speculative argument, check to see that your conclusion is the most sensible one to draw from the argument's premise or premises, remembering that the simplest explanation is probably the most sensible as well. If you are interested in exploring the subject of arguing effectively any further, the best book I've yet to read on arguing effectively is Julian Baggini's The Duck That Won the Lottery, and 99 Other Bad Arguments. Best wishes, Nick.